on this morning's docket. That is case number 109388, 109389, 109390, Stanley versus Sullivan. Council may now approach and present their case.
Chief Justice Gerald E. Wells, Lawrence for the petitioner, and I would reserve 3 minutes, please.
3 minutes is granted.
To please the court, I would like to spend my available time today talking about the language that's used in the statute in question on this appeal, which is 2012 sub 5929A24. We have a narrow issue in front of us today, and that's why I believe that the law would indicate to this court that the language and whether or not it is plain and unequivocal on its face, or should this court contemplate going behind the language to determine whether two things, whether it's ambiguous and therefore contemplates going behind and contemplating what the legislative intent was.
What's your best argument for why we should interpret the statute that is, in a way, I know direct in the plain meaning of what you're espousing, but is absolutely contrary to what the legislature intended?
Well, Judge, I would take issue, I guess, with the statement that it was contrary to what the legislature intended, because the plain language of the statute itself, particularly is to subsection D. And I would point out to you that, as the Court of Appeals said, what we are contemplating here is section 1, not subsection, section 1 of this particular statute. And as a matter of fact, if you take that as section 1, and there's no doubt, it's undisputed, that's what we're talking about, one section out of a statute, and then you go to subsection D, it says the provisions of this section, not subsection, this section, shall not apply to a writ of habeas corpus. And then if you contemplate the language in subsection A, and it describes with a very broad brush the kind of, it includes almost every kind of lawsuit that might be brought.
Except D tells us it doesn't apply to habeas corpus.
I'm sorry, I didn't.
Except that subsection D tells us that subsection A does not apply to a habeas corpus, doesn't it?
Right.
So how does this statute displace common law? Isn't D a very clear statement by the legislature that this section in its entirety does not apply to habeas corpus actions? So don't we just look to common law when we are dealing with the habeas corpus?
Well,
we don't have
I
a
think,
statutory statement at all.
Justice, I think that is true. And as a result of that, of course, we haven't reached the merits on this case. We have, my client has appealed solely on the due process angle of his case. So the narrow issue is, does common law that applies to 1501 habeas corpus actions, if what you're saying is true, and I believe it is, then whatever action is brought, 1501s are exempt from the statute.
Right. And so we fall back to common law, and
We
isn't
do.
there a common law requirement of exhaustion of administrative remedies?
Not in its entirety, particularly when you're talking about due process issues. Now, it may well be that in the process as set forth in the administrative remedies in Larned, that's administered for the most part, in my experience, by either a master's degree in sociology type of person or someone that's got a doctorate in psychology, can make an appropriate ruling on a due process question. That may happen. I don't know, because again, we haven't reached the merits of this case. But that being said, there is case law, and I think there's probably little tension if you read Merrifield, if you read Williams, and then the supplemented cases that I've provided. There is tension about whether or not, on a due process constitutional claim, whether or not it is absolutely required that you go through the process of whatever remedy is available at Larned inside the program. For that reason, I think that this is absolutely clear, and I've said this from the beginning, that the court should not have to go behind the language, although obviously there was testimony by Judge Gatterman at the contemplation of this bill and of this statute when they had hearings on it. Judge Gatterman's in a tough position because he has all of these cases that are on his docket, and it certainly would be helpful to him as a practical matter to run all of his cases through and exhaust administrative remedies. But that's good only up to a point, and that is whether or not this particular piece of legislation solves that problem pragmatically. And it's our position that it does not, simply because of the tension that I mentioned, plus the fact, again, I as a practical matter, if you run these 1501 cases through the procedure as outlined in Right 106 and Right 109, I don't know that you don't end up in the same place, because if we assume that we're not going to get an appropriate ruling on a due process argument, you're going to end up in Judge Gatterman's courtroom anyway, and probably here, unless we settle these issues. Again, I look at this, my client looks upon it as a pragmatic question, but it is obviously more than that. And the issue here, the narrow issue here, does it, as the Secretary would argue, that subsection D only applies to subsection C, I believe, which is the prior section. And what that section says is that you only have 3 shots at the cause that you are arguing and the lawsuit that you might have brought. I think there's obviously, although this is ancillary to our question here, that's probably got some constitutional questions as well. But in any event, there is language in the statute itself which differentiates itself from 1501. Why in the world, if they wanted to exempt 1501 or wanted to include it, why didn't they say so in the language of the statute? But they didn't. The only language that you've got in front of you is subsection D, and that doesn't fit. For example, there's language here, notwithstanding any filing fee or any portion thereof that may have been paid, the court shall dismiss the case, etc. Well, in 1501s, you don't pay a docket fee. So again, there's another differentiation as between 1501 and what is contemplated here in terms of the kind of lawsuits that should be heard. So it is, again, our position, Justice, that the plain language, and if you look at the plain language of all sort of 3 sections of this statute, it simply says that writ of habeas corpus and those particular provisions don't apply, as you have pointed out. There is also opinion from the Court of Appeals that the writ of habeas corpus under 1501 is included in the admonition because it is mentioned in 60-1501C. But if you look at that, I'm not certain that bolsters the case, because that simply says you have a time limitation and you have to file it in 30 days once you have completed and exhausted your remedies. That does not say, as the Secretary would have you believe, or the Court of Appeals for that matter, that exhaustion is mandatory. It doesn't say that. All it says, you have 30 days after the exhaustion if that is what happens. So I'm not certain that at all that changes the playing ground, as the Court of Appeals would tell you.
What's the remedy you seek, Mr. Wells?
Pardon me?
The remedy that you seek is that these we apply the statute under your interpretation and send them all three cases back to the district court.
Right. For not exhaustion, but to have it heard by Judge Gatterman as to the due process argument that my client has set forth in his original petition. And as a matter of fact, he may have some very good arguments, some viable arguments. If you read Right 106, it reads almost like a Star Chamber proceeding. So I think the main purpose that my client has in appealing is to get a ruling on the due process issue in this statute. Now, again, we haven't had a ruling on the merits of that. We have come up here with a very narrow issue.
Right, and so what you're wanting then is to send it back for a hearing on the merits.
Yes.
Right.
And kind of to follow up the question I was asking you earlier, if common law exhaustion of remedies needs to be explored, was that pled broadly enough to be preserved as an issue at the district court? I mean, was exhaustion of remedies tied only to this statute, or was there a general failure to exhaust administrative remedies?
As my pro se client, I think, stated adequately, it was painted with a broad brush. I think broad enough to include the common law remedies. But don't know that until we have a ruling on the merits.
Counsel, I see you're out of time. Do you need 30 seconds to wrap up? Do you believe you've stated
No,
your
I think
position?
I've said what I need to say, Chief Justice.
Do we have any questions? Thank you, counsel.
Yeah, thank you.
May it please the Court, Kimberly M.J. Lynch on behalf of Secretary Bruffett, the Kansas Department of Aging and Disability Services Secretary, representing the appellee. Due to the conflict within the statutory language at issue, this Court can and should look to the legislative history of the statutes.
What's the conflict?
The conflict is, well, there's inherent conflict within KSA 5929A-24, and then if you look to KSA 60-1501, which I believe you have to look to that because that is the habeas statute. So it's apparent and necessary for the court to look at both statutes together, especially because in 2012, when these things were looked at by the legislature, they were looked at together. Section 1 was 5929A-24, Section 2 was 60-1501. They were all part of the same bill, which was the substitute for Senate Bill 74. It's important to first look at 5929A-24. And if you look at A, it's clear. The legislature was clear that residents of the Sex Predator Treatment Program, prior to the filing of any civil action, are required to exhaust their administrative remedies. And they're required to prove or to demonstrate the exhaustion with their petition. Then if you look to 60-1501C, the legislature talked about exhaustion there. If you look at the 60-1501B, the language is identical, and that's important, I believe, here from questions that were raised earlier about the language. While it does talk about you have 30 days after a final action has been made by the agency to file an action, but such time is extended while they're pursuing exhaustion.
Why isn't that superfluous if it's mandatory? The subsection C says that 30 days from the date the action was final. And then it has the proviso, but such time is extended during the pendency of the patient's timely attempts to exhaust the patient's administrative remedies. If exhaustion is required, then your action wouldn't be final until those had been exhausted.
Well, if you look to B, which is the section that this was created off of, and it deals with inmates, it's a long historical practice that there has been the requirement of exhaustion, and B was the one that required it. The purpose of it is there are times that there may be an extension.
Excuse me, Counselor, we're talking about the language, and my specific question is, if administrative remedies must be exhausted mandatorily, then your action would not be final until that was done. Would you agree with that?
I do agree. I think it makes it clearer.
So then the statute, if that were true, the statute would stop after the word final. You wouldn't have the proviso, but we extend the time.
Well, I think if you look at it, who are the type of people that file these claims? They're usually pro se predators that file these claims, civil committees. Not everyone understands that final action and when something is final. By saying that such time is extended for the timely attempts to exhaust, that lets them know that they can get extensions of time for exhaustion, that exhaustion is a part of that process. I think that language is important to demonstrate the pertinence of exhaustion. Again, I think it's important to note that the legislature copied that language from B that's been used historically with the Department of Corrections. That's important because they're both confined settings. And for decades, they've required exhaustion with inmates. Why that's critical here is that in both settings, these individuals are in a confined position. They're filing a writ of habeas corpus to argue about conditions of confinement cases. There, exhaustion is a benefit to everyone. If you first look, I believe it is clear there's a conflict because both statutes talk about this requirement of exhaustion, 60-1501 and KSA 5929A24, but then there is D. You can't ignore D, and it does say the provisions of this section shall not apply. Well, that could apply only to C, as we're arguing, and that would be...
Where do you get that? Can you point to any place in, and maybe you can, where in any chapter of any of the Kansas KSAs that are sitting on your table there, can you find where that occurs, where we have a section referring to a subsection that doesn't say that? I couldn't find one. Can you find one?
Well, I think you have
that's
to...
just where does that come from? I don't even, where the Court of Appeals says that, you say that, where is there an example of that?
I can't name for you a specific Kansas example.
I don't think it exists.
What we can say, though, is that if there is an inherent conflict, which A is clear, they say any civil action. And if you say any civil action, a habeas corpus action is a civil action. So there's conflict. If you get to conflict, then you can look to the canons of statutory construction.
I don't understand how there's a conflict if you have a rule and an exception.
It's our argument that it is an exception because you have to look to 60-1501 too, and when you look at them together, there's two different statutes. Both are talking about exhaustion, and then there's this D, and that is in conflict with the other two sections, the two different statutes, either A or 60-1501.
I don't know that that's necessarily true. If you have an exception that takes it out of 29A24, then why doesn't it mean that the habeas statute is the statute that would control?
Well, I think you have to just look at part of the process here when you have these types of issues is to try to have everything harmonized. And that's part of the goal of the Supreme Court. There are many cases about that. If you were to read D to say that it doesn't apply to habeas corpus, then that would lead to an absurd result.
Why?
Because
before the statute was there, it was governed by a set of laws. I don't think that is an absurd result to rely on common law or even the habeas statute.
Well, if you look to the traditional habeas corpus cases, in every other genre, individuals are required to exhaust.
And I don't see why that is still not possible under that reading. If you just say that 29A, 24 doesn't apply, then we are back to the area of law that we had, the body of law that we had without this statute. It just doesn't change anything. So we still have all of those rules about exhaustion of administrative remedies in play.
What my colleague's suggesting is if you haven't enacted anything, if you haven't codified, then you have the common law, and the common law may get you where you want to go. She's asking you why that doesn't happen.
I do agree with you, and I agree with the common law, and there's historic purposes there. I think what I want to make sure that is addressed, just so that we've covered it, is that Merrifield case it's not even published, but it's a Court of Appeals panel in 2009 that said that they weren't required to exhaust. And so it's one of the reasons why the legislative history is so important is because part of that is so that they could have codified that rule, so that is a rule. I don't want the common law to be displaced by this one Merrifield case when the whole body of common law does say that exhaustion of administrative remedies is important, and I would agree with you wholeheartedly. We would agree with you because there are so many benefits to exhaustion. It benefits the residents, it benefits the court, and it benefits the agencies because there's a record, and the record is created right at the time of the incident. So then when these things proceed to court, you have all the evidence you need, and ideally, if the resident strongly believes they've been harmed in some way, they have all the evidence they need to prove the harm. The court has everything they need before them to demonstrate the claims, and then the agency would be able to defend. And so that's why the common law is so important, and I would agree with you that that's why historically we've required that, so that these issues are fleshed out by the time they get to the court.
So then what was the purpose of enacting this statute, in particular Section D, if the common law requirement still stays in place? Why is it there?
Well, again, in order to be able to answer...
It says something very clear and plain and precise. Why is it there if it just takes us back to where we were? I mean, they don't enact legislation without a reason.
Certainly, and I think that our brief tried to spell this out pretty clearly. I think there are times when there's essentially a typo, and something happens where there's a typo. You have to get to legislative history to see that. But if you look at all of the minutes, the meeting minutes, the D.
But you don't
section,
get there. That's where you don't get to the testimony and all that when you have this plain language. I just don't see how you get there.
Well, I believe this court on several occasions where they felt like something may be ambiguous or unclear, where there's a conflict, where I would argue there is a conflict here, that you're allowed to look to the legislative history. And if you're going to read something in harmony, you want to get to the purpose of the legislative intent. It's critical, and especially in an instance like this where it would be absurd to not require exhaustion. It would go against common law, it would go against everything as you're saying. It would lead to an absurd result. And if you do look at the history, the legislative history, it's clear. You can't ignore that exhaustion is required.
It leads to an absurd result. What if they're, this is just a for instance, what if they're engaging in some sort of aversion therapy at the unit that is contrary, that's the petitioner believes is torturous? You would say that they would have to exhaust all their administrative remedies before they could bring a case. I mean, that's an extreme example, but that's not an absurd result.
Well, I would argue that could happen in any habeas setting when you're in a confined setting, and they've required exhaustion in every other one. So this wouldn't be any different than any of those cases. And even there, just to know how the process works, there are special grievances that you could do immediately, emergency grievances. So if there's a situation of torture, I would hope that we use the emergency grievance.
Actually, I thought the record was pretty unclear about that on this particular unit, or at this particular place of confinement, about how the grievance procedure works. It was pretty unclear. The steps weren't really articulated very well. It's just
part of that, Your Honor,
pretty
and I apologize.
informal. Actually, pretty informal.
We were not a party to the case below. This was something that was summarily dismissed, but classically in Kansas, we were made to argue at the appellate level, so that there's not a default judgment against us. But we didn't have the opportunity to respond. Had we had the opportunity to respond at that level, we could have shown the grievance system. That's something that could be fleshed out in another case. And actually, I would put before you that there are other cases right now out there, and that is an issue that can come before the court at another time to show how extensive the grievance process is. And in the 2 years that it's been operating under the new process, we've had great successes with it. So I think at another time when that comes before the court, you will be impressed by what you see. And there is an emergency grievance procedure, so if there was something that was inherent, so something of a physical nature that needed to come before the court quicker, it certainly could. This wouldn't limit that. think it's important just to realize that exhaustion it's beneficial to everyone. There's not any negativity with exhaustion. This helps the residents themselves. There's really no reason to not require exhaustion. I think the language in A was clear that they intended to require it by saying prior to filing any civil action. That language is very clear. They mimicked 60-1501, the legislature, after the inmate version of B, where it's always required exhaustion. The intent was to require exhaustion, even if you look at the plain language, even if you won't go with me to the history. But if you do go to the history is clear. There's plenty of testimony about C and about how they didn't want the 3 strikes provision to be applied because that's a due process issue. They should always be able to come before the court. It makes sense why D should be applied to C because you're talking about being able to come before the court and access to the court. So that's why the legislature intended it for it to be there.
Counsel, I think I understand that much. What's not clear to me is what administrative remedies you think Mr. Stanley had to exhaust before he could exercise his habeas right.
There is a grievance procedure that they would...
Walk me through it. Tell me what it is he had to do before he gets to pursue the habeas relief.
Certainly. Larned has a 3-step grievance procedure. The first one is they would take the issue to their unit leader. If they're unsatisfied with what the unit leader says, they could appeal the grievance to a grievance officer. There's an informal hearing where the grievance officer reviews and does an investigation of the issue. If they're unhappy with the grievance officer's response, it goes to the program director, and the director of the program himself will weigh in on the issue. And once that process is complete, they can take their issue to the district court. And in the past 2 years where exhaustion has been required in Pawnee County, that is happening. There have been cases that have been dismissed at the lowest possible level, which is another benefit to having this process. And then the cases that we do have before the court, it has been easier. It's already been proven and demonstrated that the issues are already fleshed out. It's easier for the judge to make a determination upon the writ, and it's easier for the resident to present his claims. It's easier for the agency to be able to defend those claims.
Would you agree that there's a very real risk here that the administrative agency, maybe not yours, but an administrative agency, could put enough burdens between a person and the district court that it would effectively take away the constitutional remedy of habeas?
Could that ever happen in the realm of possibility? Maybe. But is it happening here and now with our agency? No. And I think that's important to look at the agency you're talking about. I can't say what could happen in the future, but I can tell you right now this is an important remedy for everyone. Exhausting the administrative remedies truly is helpful because it identifies all the witnesses at issue. Like, look at here. One of these is a nightlight claims. One of the ones before you right now. There, if you get the facts involved, like, why is the nightlight there? What's the policy that requires the nightlight? Who said that we should have to have a nightlight? By the time you get to the district court, you have all these policies and you know who's the one that put the rule in place. And so the judge can go directly to the source. The resident can go directly to the source. If you're talking about a property issue, all of these are property issues. So I wanted to order something from Walmart. They said I couldn't have it. Well, who's the property officer that said you couldn't have it? Why can't you have it? Is it contraband? Is there a policy about that? You find all of that in this administrative review process. Within those 3 tiers, you're going to get all of that fleshed out. When it gets to the court has all of that in front of them, not just the petition, but they have the policy, they know what the property was, they know who the officers were. So if and when we go to hearing on a factual issue like that, we already have all the players that have been identified. And I'll even argue that with their counsel, they get counsel if they're represented at a hearing, if it goes to hearing. Their counsel and our counsel have been able to work together to have joint pretrial questionnaires. It makes the whole process smoother. The court is already aware we don't have to do any discovery. Everything is ready for the hearing, and we go to hearing.
I'm sorry to interrupt, but your time's out, and I want to know a little bit more about the administrative process. Are there time constraints for the agency that once, and I want to say inmate, but once a person invokes the administrative process that you know you're going to be done by a certain time?
Yes, Your Honor.
What are those?
I believe it's 14 days in between each one, that as soon as something is filed, there's 14 days to respond at the unit leader level, and then 14 days at the next level, 14 days at the next level. However, if for some reason there isn't a response, so if the unit leader doesn't do it, or if the grievance officer, if someone gets hung up, it gets stuck on someone's desk, the resident's allowed to proceed to the next level without getting an answer. And that's to make sure that you don't get a clog, that you don't have a list of grievances on someone's desk. So the process is meant to ensure that it goes forward without delay. And for all these reasons, we've talked about the benefits. I believe it is clear the legislature intended to do this. The plain language is clear. And for these reasons, we'd ask that you find the district court did not err when they required exhaustion of Stanley's cases. Thank you.
Do we have any further questions of counsel? Thank you. Yes, you reserved 3 minutes for rebuttal.
I would like to go to Justice Biles' question in particular. If you look at Right 106, which is the process that has been promulgated by the Secretary, there are two issues there. There may be more, but two come to mind that I think should rise to the level of a question as to the constitutionality of the process. One is that whether or not there is a hearing in the beginning steps of the process is totally up to the officer. That officer can say, we're not going to have a hearing because for whatever reason, this is frivolous or malicious or whatever. So look at that particular beginning process. Secondly, as I remember the wording correctly, witnesses that may want to be called by the petitioner or the person who has filed the grievance, the hearing officer decides whether or not those witnesses are relevant, for lack of a better term. So those are two areas where I think the constitutional due process requirement is implicated. Now, when you have a hearing officer who's supposed to be a neutral party in these hearings, grievance hearings, decides whether or not there'll even be a hearing, and if you want to draw on witnesses, then the hearing officer, without any input or without questioning by the person who has the grievance, I think that's a serious matter. We sort of strayed from the point here, but I think that it is not, my colleague Ms. Lynch said, well, we have these wonderful processes and we have an appeal process, and the grievance, the person who brought the grievance has this right and this right. But I think this court has to look at, if we're going to talk about it, Right 106, whether or not due process is really fulfilled in that. So if it's not fulfilled, if it is not contemplated, if it's not implicated, why then does that person have to go through that process? Now, we haven't had ruling on the merits for sure, but I think this court has to look at that and see whether the Secretary has really promulgated a process that protects those rights.
But I think I understood you to say that you agree that that's not before us in this case.
Right.
And I mean, Mary,
Well, I raised the point because Ms. Lynch and
Right,
Justice Biles
right.
raised the question.
But in terms of any ruling on the procedure or on whether Merriweather was correctly decided or anything like that,
Right.
none of those issues are here today.
No. I hope I pointed that out. Okay, thank you.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.